We are waiting for whom?
Good afternoon, everyone. I'm Anubhav Kapoor, Director of Legal Affairs at Ford India. I'll be your host for today's webinar, where we will be discussing a few legal opinions on directors' responsibilities and climate change under the Indian law. The event is jointly organized by Commonwealth Climate and Law Initiative, CCLI, and the Society of Indian Law Firms, SIFL. Just to give you a background, there is an overwhelming scientific consensus that human activities such as the burning of fossil fuel, land clearing, and agriculture contribute significant volumes of greenhouse gases into the atmosphere. According to the IPCC, the gold standard for climate science, the release of excess GHGs, greenhouse gases attributable to human activities, has already caused approximately 1.1 degree of global warming across average pre-industrial temperatures, which is quite a concern. This human-included climate change is already having a profound effect across the world. And that kind of gives us a reason to discuss this important topic today on the panel. We have the roadmap for solutions with the Paris Agreement, where the world's governments have agreed to transition to net zero emissions and limit warming to well below 2 degrees Celsius and strive for 1.5 degrees Celsius to avoid the most catastrophic impacts of warming. This means that we need to have half our emissions in the next decade. This will require systems, transitions in energy, land use, industrial and transport, and how we produce and consume. With the scientific consensus on climate change and global agreements to transition to net zero emissions, climate change has rapidly evolved from a singularly ethical or environmental issues, and it is now widely recognized by leading market stakeholders such as prudential regulators, institutional investors, and credit rating agencies that climate change presents material financial risks and opportunities for business and investments alike. The physical risk from the acute and chronic impact of changing climate and the economic transition risk from a policy, regulatory, technological, and market stakeholder shifts as we decarbonize our economies, and the litigation and liability risk for causing climate change or failing to adopt or disclose these risks. So what does this mean for company directors in India and their duties to act to the best interest of the corporation and exercise due skill and diligence? Today, our speakers are here to explore these issues with perspectives from directors, academia, and legal counsel perspective. Before we get to the discussions, few housekeeping issues. Attendees, please submit questions via the Q&A function in the bottom of your screen. We will take that at the appropriate time as we go through the discussions. And also keep yourself muted so that we don't have unnecessarily sound interferences. With that, let me introduce to the speakers. Today, we are honored to welcome such a high caliber of renowned speakers, generously giving their time and expertise on a pressing and significantly evolving issue. I take the pleasure of introducing Dr. Lalit Bhasin, who is director of a very well-known firm, Bhasin and Company. Mrs. Neera Sharma, a board member, a CEO and CLO of Sistema Smart Technologies. Mr. Cyril Shroff, managing partner, Cyril Amarchand Mangaldas, one of the leading law firms in India. Mr. Umakanth Varottil, associate professor at the Faculty of Law, National University of Singapore, author and founder of India Cop blog, and Felix, who is the UK lawyer for CICIL, and he does extensive research on issues of climate change. He will be our expert panelist on climate change issues outside of India. In the interest of time, I won't read their full biographies. They have been put on the link of the event page in the chat function if you'd like to refresh on their expertise and achievements. And without much ado, I'd like to start by inviting Dr. Bhasin, President of the Society of Indian Law Firms, to provide their opening remarks on this very important and interesting topic. Over to you, Mr. Bhasin.
Thank you, Mr. Kapoor. Mr. Kapoor, Mr. Cyril Shroff, Ms. Neera Sharma, Mr. Umakanth Varottil, Ali Mulholland, Julie Luanco, and Alex Cooper, and other participants. This webinar is a brilliant and timely event organized by Commonwealth Climate and Law Initiative, headquartered in London. SILF is privileged to co-host this webinar. The webinar is essentially focused on legal opinion by one of the most eminent lawyers of India, that is Mr. Shyam Divan, whose reputation goes beyond the shores. He is known across the globe as a brilliant lawyer fighting for human rights, fighting for the law of privacy, and also in the climate change. It is a well-researched, profound, and exhaustive opinion on the theme climate changes and directors' duties. When we talk of directors' duties, that is where the role of SILF and the SILF members, that is the lawyers, comes into the picture. Because we are business lawyers and advise the corporate world, the in-house counsel, and the board of directors of the corporate sector. That is where responsibility of advising clients on compliances shifts to lawyers in the first instance. This includes advisories to corporates for compliances with laws and regulations relating to climate change, as highlighted in the legal opinion. The discussion today will be very fruitful and thought-provoking. This webinar is meant to bring together and connect minds to debate, collaborate, innovate, and ideate for a better and more sustainable world. Not mere compliance is required under the law, but the overarching super and supreme law of human rights also has to be adhered to. And in this connection, I would like to quote the chief of the Human Rights United Nations Commission, that is Michelle Bachelet, who only last week in Geneva, she said that recent months have unleashed extreme and murderous climate events, citing the fires in Siberia and California and floods in China, Germany, and Turkey. She also said drought was potentially forcing millions of people into misery, hunger, and displacement. She was not alone, because the same sentiments were echoed by no other than one of the most eminent law teachers, that is Professor John Sherman, who teaches at the MIT School of Management. He said, and I quote him, "We have already warmed our world above pre-industrial levels. The harms from even that are obvious to all now. These include wildfires, drought, crop yield declines, sea level rise, more extreme storms and flooding, and the migration and conflict these create. All these disrupt supply chains through interruptions to sourcing, production, transport, and destination markets. Consumers can expect higher prices and much more volatility in the availability of products as climate change increasingly disrupts the production of commodities. The most important immediate action for companies and countries is to reduce their greenhouse gas emissions as quickly as possible. Without such cuts, global warming will continue, threatening our prosperity and security. The world's poor will not be able to rise out of poverty. Instability will increase and the harm to businesses and people will be profound. There is no time to waste. Furthermore, companies that cut their dependence on fossil fuels by investing in efficiency and renewable energy increase their own resilience. They will be less vulnerable to disruptions in energy supply and wild swings in energy prices due to the physical harms from climate change and transition risks as the governments impose policies that will raise costs and reduce the availability of coal, oil, and gas, etc. Now, what is required is also need for a global cooperation and understanding. India meeting its climate targets and transitioning to a decarbonized economy without shortchanging its development goals are key to the global goal of restricting warming. The partnership with the United States and Britain addressed that space by focusing on mobilizing investment, channelizing funds into green projects, and working on innovative technology. The partnership with Britain, that is US $1.2 billion investment by both in green projects in India, joint investment by both government to support the companies working on innovative green tech solutions, and a climate financial leadership initiative to mobilize private capital into sustainable infrastructures in India. This support should help India transition to a low carbon economy, a key part of clean energy technology. We must now develop a long-term plan for an economy-wide transition to a low carbon pathway, building climate resilience and build carbon sinks. To the same effect is the approach from the United States, where John Kerry, the presidential envoy on climate change, visited India, and he assured India that US will assist India in attracting finance and technology to achieve its 450 GW renewable energy target for 2030. What is the advice to the board of directors and to the businesses? Businesses must strategically rethink business models with a nudge from the investors. There are concerns that while on paper, companies and investors commit to sustainability, often returns assume primacy and the do good for all motto is subverted. For the private sector to take heed of the warnings, the scientific results must be translated into the language of finance. That is, the impact of climate change needs to be demonstrated as potential risk and returns. Therefore, risk is a very element factor which the board of directors must consider in addition to the compliances which are required as set out in the legal opinion. In India, fortunately, the Reserve Bank of India has a relatively broad mandate to maintain price stability. Thus, incorporating green finance within the folds of the bank's mandate won't be a challenge. The Reserve Bank of India joining the Network for Greening the Financial System, that is NGFS, this year signals a positive step forward. As the clock ticks on the climate change, it is ideal to begin by understanding what it means for India. The financial sector responds best to the Reserve Bank of India's action and a proper assessment accompanied by disclosures of climate risk, and it can pave the way for action. I thank, you see, the climate Commonwealth Climate and Law Initiative, and in particular Ali Mulholland, Julie Lonko, and Alex Cooper for this brilliant initiative, which SILF is proud to have been associated with. I wish all success. Thank you very much. Thank you.
Thank you, Mr. Bhasin, for those brilliant opening remarks and insightful overview on the topic. For those of you who joined after the session started, please follow your chat box. We have the link to the legal opinion, and also Professor Umakanth had his article published in Bloomberg. So without much ado, let me invite Professor Umakanth to summarize the findings of the legal opinion and the accompanying white paper on directors' duties and disclosure obligations under the Indian law in respect to climate change. Professor Umakanth is an academic and author specializing in corporate law and governance. And would you please summarize the key findings of the legal opinion and the accompanying white paper to set a background of our discussions before we get to the detailed issues pertaining to the subject? Professor Umakanth.
Yeah. Thank you, Mr. Kapoor. I'd like to acknowledge my thanks to CCLI and SILF as well for involving me in this project and also inviting me to speak today. So I have some slides which I will share. My purpose today is mainly that of a messenger. So a lot of what I will be doing is summarizing the legal opinion which you have before you that was alluded to a little earlier. That has been provided by Mr. Shyam Divan, Senior Advocate, and his colleagues, Ms. Sugandha Yadav and Ms. Ria Singh Sawhney. And I will also touch upon the accompanying white paper that I have authored as well and try to summarize the two. This is going to be a daunting task because the legal opinion is 37 pages long and the white paper is 65 pages long, and I'm undertaking to summarize this in 10 minutes, but I will try my best to do so. So as was mentioned just now, climate change has been recognized as a material financial risk around the world, and companies have already begun facing lawsuits on this basis, both in terms of board decision-making and corporate governance, as well as disclosure-related issues. And this has become an important issue even for companies because scientific evidence is increasingly becoming clear that is pointing out the connection between corporate activity on the one hand and the impact of climate change. So as was pointed out by Mr. Bhasin as well, companies do face various types of risks. We've seen physical risk in terms of floods, unusual weather patterns that just affect not only the companies, but also the supply chain along the way and causing a lot of disruption. Transition to a zero carbon global economy is another risk that companies face. And finally, the risk of litigation on environmental and climate change related issues. So companies do face a lot of risks, and how do the board of directors deal with these risks? And as is very well known, directors are fiduciaries who owe their duty to the company. And in the Indian context, directors are also imposed trustee-like obligations. And when we think about trustee-like obligations, historically, we've been talking about obligations in the context of shareholders. But as we have seen, once company law was codified in section 166, which I'll refer to briefly, the trusteeship obligations become wider in terms of society itself being the beneficiary, and so the environment as well. So the trusteeship obligations become quite wide in nature. So to divide the types of duties that directors have in the climate context, there are different types. I won't run through all of them, but I will touch upon a couple of them briefly in sequence, and the legal opinion and the white paper refer to these as well. The first and most important aspect is the statutory recognition of climate type issues in the Indian Companies Act itself of 2013. And here, and I stand by researchers who've looked at this issue in other jurisdictions as well. India is unique in two ways. The first is there's a clear understanding that directors have to act in the best interest of the company, which is well known. It's universal concept. But secondly, India is perhaps the only jurisdiction in a leading economy that has a specific mention in statute that directors have to act in the best interest for the protection of the environment. So this is a very high threshold that directors of Indian companies have to satisfy. And this is something implicit in other jurisdictions, but it's quite cast in stone and explicit in the Indian context. So I will take each of these in sequence, what the best interests of the company are, and what does it mean to protect the environment. So best interests of the company, it is well understood that what is generally meant is the long-term sustainable value of the company, whatever that means, and not necessarily the short-term myopic shareholder interest only. And this is increasingly becoming clearer in various jurisdictions around the world. And I think 166 makes it pretty clear in the Indian context. So climate change issues are generally something that affect companies in the longer term, and directors cannot afford to ignore the long-term interests and long-term sustainable value for the company. So what does this mean for directors of an Indian company? This might mean that directors cannot ignore climate risk. They have to make a detailed assessment, depends on the industry, depends on the type of companies. And where they do not have in-house expertise, directors may also have to consider obtaining expert advice. And based on that, also determine strategies to address that risk and implement those strategies going forward. So ultimately, it's not just the stakeholders, not just the environment, but it also pinches value for the shareholders themselves. So today, the importance is not just from a societal perspective or a public interest perspective. As we've seen, since climate change has a material financial risk to the company, it also has an impact on the shareholders themselves. So it's not just a matter of corporate social responsibility or philanthropy or societal interest only. It hurts where the financial interests lie as well. And as we've seen, there is an explicit mention of the environment, which is where the climate interest does come in. And the legal opinion also refers to a fairly recent decision of the Supreme Court, which is mentioned on the slide here, which explicitly refers to the concept of environment recognition in the Companies Act itself. And the court goes on to say that what is meant by environment in Section 166 of the Companies Act is the same as the use of the expression environment under the Environment Protection Act. So in some ways, you see a confluence of corporate law in one sense and environmental law on the other. No longer are they two distinct aspects from each other. Courts are beginning to look at them together, in a way expanding the scope of directors' duties into the realm of environmental law as well. And as the opinion clearly says, this case also shows that there is no fixed hierarchy of the duties owed to the company and the stakeholders. All of the stakeholders mentioned in Section 166 are important, including the protection of the environment. And the opinion clearly says a decision taken seemingly in the financial interest of the company and its shareholders, but which is detrimental to the environment, may transgress Section 166 of the Companies Act. So pure shareholder-oriented decision-making may be risky for directors. It requires a more holistic consideration of various different factors, of which the environment and climate change become an important component as well. So that's as far as the the duty is concerned regarding the environment. And even more important, there are general duties as well. And one of the duties is what we would call as duties of competence or negligence duties, which says directors have to act with due care due and reasonable care, skill, and diligence, and also exercise their independent judgment. So this doesn't say anything about climate, but climate is implicit in this understanding, because if directors fail to account for climate risk, they may potentially run the risk of breaching this particular duty as well. And I don't have the time, but also the Companies Act, as well as the SEBI regulations for listed companies, do deal with an extremely expansive risk management framework. And as we've seen, climate risk is a significant risk today. And so companies that have risk management committees of boards would, and the members of those committees would significantly carry an onus in addressing climate risk as well. What happens? Directors cannot afford to fail to consider climate risks. These are material. The standards could be different for different types of directors. Again, as we know, the Indian Companies Act has a specific code of conduct or a specific code for independent directors. So independent directors are not off the hook. It's not just the management of the company. Even they do need to have a clear understanding of what the climate risk is all about. And certainly the risk may also vary depending on the industry type. Some industries are naturally vulnerable to the effect of climate change. I've listed a few of this on the slides, like agriculture, energy, transportation. But now, as was mentioned by Mr. Bhasin, even banks and financial institutions are not off the hook, because even they do have an indirect role to play in the aspect of climate change. So that's how directors may not consider climate risk at all, but it's not enough even if they consider climate risk inadequately. If there is an issue that comes up on climate change, perhaps there's a duty to make further inquiry. This is what we call as a red flag test, right? If there's a red flag that comes out, you cannot let that go. This requires a further inquiry to be made. This includes seeking external expert advice, or maybe also delegation to members of the management of the company to look into climate-related issues. But ultimately, the buck stops with the board of the company. So no matter what delegation, seeking external advice, ultimately the directors are, as fiduciary duties, bear the responsibility for the opinion that they pass, or the decision that may take, which is again quite a clear aspect of company law. The third and important issue is the question of disclosure. Now, disclosure is an important element as well. Sometimes we think of disclosure as check the box compliance issue, but the more serious and stringent the disclosure norms are going to be, it has the effect of altering the conduct of companies and boards itself. And as we've seen in the last decade or so, the disclosure norms, especially on the sustainability issue, have developed fairly significantly in the Indian context, that has upped the ante as far as climate issues are concerned. And SEBI, the securities regulator, has done a very important job of tightening these measures along with the Ministry of Corporate Affairs. So there is a fairly robust set of disclosure norms which directors have to look into. So when do these disclosure norms bite? Firstly, it bites when a company is going to make an offering of securities. So certainly there are prospectus and disclosure requirements. And I would imagine that climate is an important issue in disclosures, especially in climate sensitive industries. And IPO is one phase, or any kind of securities offering where directors have to really be vigilant, because the prospectus cannot carry misleading statements, because that would subject them to liability as such. Then you have secondary market disclosures, when companies have to make disclosures of material financial changes, and materiality is subject to interpretation by the courts and the tribunal, the Securities Appellate Tribunal in the Indian context. And I think it's a no-brainer to suggest that issues like natural calamities and litigation risk from a climate perspective would be material information, subject to other circumstances being relevant in that context. And the regulatory authorities in India have interpreted the concept of materiality fairly widely to encapsulate risks from an environment perspective as well. And finally, as I mentioned, there is also a significant move from a business responsibility and sustainability perspective. And even here, I don't have the time to get into the nitty-gritties. The opinion has a lot of the details. There are specific requirements of disclosing issues pertaining to climate change. And this also requires directors to apply their mind into the type of identification of climate risk, how they address the climate risk, what strategies do they come up with, and how are those strategies being implemented. So the disclosure requirements would also require some of these aspects to be considered. And finally, what is the liability if directors breach these duties? And here, as you can see, it's pretty complex. So there is a number of different types of liabilities that directors could carry. Under company law, there's both public enforcement and private enforcement. Private enforcement basically means shareholders or other stakeholders could bring an action under company law, derivative action, oppression, mismanagement. And India, at least on paper, has a very, very wide provision in Section 245 of the Companies Act in the form of a class action mechanism. As far as I know, it's not been effectively utilized in any case until now, but the provision is pretty wide in nature, and climate risk could certainly fall within that as well. And in case of public enforcement, if there's a breach of directors' duties which has public interest consequences, Ministry of Corporate Affairs could also initiate potentially action under the Companies Act as well. And finally, as the opinion also shows, there are other sources of liability as well. And these could be under public law, these could be under environmental law. So for example, companies could be subject to public interest litigation from an environmental law perspective. The National Green Tribunal has become quite active in recent years and has also taken cognizance of climate change as a component of environmental law as well, either implicitly in certain cases, but that's an important development to keep in mind as well. Environmental regulators have been quite active in this regard as well. And finally, directors could also carry potential liabilities for prosecution under environmental law or for breach of disclosure obligations by SEBI as well. So just to kind of conclude, as you can see, it's a fairly evolving area. This is an area that might evolve pretty fast. And maybe one note to conclude would be, as the opinion and the white paper point out, the developments in the substantive law as far as director duties are concerned have made it pretty expansive for companies and their directors to take note of this and act on the issue of climate change. But how much is this going to be enforced? What are the enforcement mechanisms? I think there are some issues over there, and that's nothing to do with climate change. That relates to typical enforcement related issues that come up in the Indian context. But nevertheless, there are many, many areas that could be open for enforcement. And this is an arena that's also gaining a lot of traction world over. In many jurisdictions, I think from a private law, company law perspective, I think the jurisprudence is still developing in terms of how companies and their directors can be sued under company law or other private law mechanisms. And I think India is probably at the next frontier when it comes to that. And I think the objective of this effort is to educate the directors and companies to take note of these issues and to act in that regard. So that's pretty much what I have for now. And I look forward to the other comments and discussion thereafter. So thank you.
Thank you, Professor Umakanth. That was a brilliant context setting of all the issues we are going to discuss in the next hour. With that, let me invite Mr. Cyril Shroff, who has been a thought leader in this area as well, in terms of what he thinks about the legal opinion and the white paper, and share some of his opening remarks with us. Mr.
Thanks, Anubhav. And thank you, Mr. Bhasin and Umakanth, for those very engaging comments. Great topic. And also I'm quite fascinated by the format of this webinar. It's not every day that you actually have a legal opinion by one of your favorite counsel in the world, and then you kind of discuss issues around that. So it's fascinating, and I think the fact that Shyam Divan's thought process and his views on this is probably the context setup for this is very interesting. Also, Umakanth's white paper is terrific, and I think we are probably at the foothills of this whole journey on ESG and sustainability conversations that are now becoming mainstream in India Inc. But if I can just pause there and just step back for a second. So we are in the roughly the 50th year anniversary of Milton Friedman's epochal essay on social responsibility of business to increase profits. So that article and the thought process around that unleashed about 5 decades of capitalism in its kind of most extreme and pure form. And it was the foundation of what we see as a kind of modern capital markets, the new corporation, and a particular genre of thinking. And it, of course, also came with a whole pile of environmental degradation attached to that, because it was all very selfishly oriented towards only one stakeholder, namely the shareholder. However, in the last decade or maybe a decade and a half or so, the dialogue has changed, especially after the financial crisis. And there are 3 or 4 kind of milestones in that. There are many, but I'll just pick out a few. The first was the doctrine of what's called the new paradigm, which was articulated by, again, one of my favorite lawyers, Marty Lipton at the World Economic Forum, where he laid down a whole sort of a set of criteria in terms of, again, how should corporate governance be perceived, and the relationship between a corporation and the and other stakeholders. And it was one of the seminal events that kind of led to a new form of stakeholderism related governance format. Not necessarily, unlike India, which, as Umakanth pointed out, where statutory under section 166, this was essentially more market driven, as well as eventually sort of becomes part of the sort of judge-made law as well. And the new paradigm and the articulation of it has been driving a lot of conversations on corporate governance in general, and within that, some of the ESG and sustainability conversations. So that was one. The second one was a kind of whole stream of thought, of which there were, of course, many contributors, but Professor Colin Myers was one of the leaders of that, in terms of how we articulated what is the purpose of a corporation. And the purpose of a corporation is not merely to make profits. It is the license to operate, which a corporation gets. And going back 250 years or more, when the earliest corporations were invented, there was always a kind of a state license to operate that was given, which was always for a purpose. So he took us back philosophically to what is the purpose of a corporation. And I think he, in substance, in simple terms, concludes that it cannot merely to make profit. There has to be a larger social purpose or an objective to it. And having done that, we have seen in the last, probably in the last 5-6 years in particular, a strong focus on what is the purpose of a corporation. And more purpose-led corporations are the darlings of the capital market. And even one of the kind of most, most prolific writers and thinkers on this is Larry Fink, who is the chair of BlackRock. In his annual letter to the investor community, always brings up both ESG themes as well as the purpose of the corporation. So that's another kind of whole stream of thought which developed. Then there were others as well. I think the famous Business Roundtable, which was led by Jamie Dimon of JP Morgan, and he got a whole lot of global corporations together in terms of really thinking about linking these themes, both the new paradigm as well as the purpose of a corporation. And that had a seminal effect also in terms of how a lot of major boards and global corporations started thinking. So sustainability and ESG and purpose of the corporation, all linked themes, started becoming mainstream. In parallel, of course, the capital markets and particularly institutional investors, especially the index funds, mainstreamed the agenda as well. And there was effectively a kind of a rise of sustainable capital. And we saw that not only in the equity markets, but also in the debt market. So as Dr. Bhasin was saying, green finance, and again, that has become mainstream in India. So both on the debt and equity markets, we are seeing the greening of both these instruments. and the driving of a particular agenda. The third thing which I think it happened in India, other than, of course, Section 166 and the thinking that lies behind it, and it's sort of a good point of time to think of just 2 days after Gandhi's birth anniversary, is kind of a rediscovery of the Gandhian concept of trusteeship, whereas each generation effectively holds the assets, the infrastructure, the environment in trust for the next. So maybe it was a very nuanced concept which India didn't realize as it kind of went through the early days of creating environmentally unfriendly infrastructure. But it is making a lot of sense these days in terms of thinking about the concept of trusteeship as we approach this. Now, the law also evolved in parallel, 166, and I won't belabor that. I think Umakanth has covered it well. But we are truly, I think even my research shows that we are probably the only country in the world which has legislatively brought in the concept of stakeholderism into the statute. It's not as if we are the only country in the world which follows the stakeholder model. I think a lot of other jurisprudences have moved towards that, but we have gone a little further. We have actually put it down in the statute and made it a part of the duty of the board of directors, and which is today's conversation as well. But there are some gaps which we'll come to. Some of them I think Umakanth has referred to, particularly in terms of, okay, you have this great duty now in section 166, but where is the remedy? Do you have to pursue your remedies only in public law through public interest litigations and things of that nature, or under the Environment Protection Act? How do you bring private law remedies to hold accountable boards of directors who essentially act within a private law framework, either as just working within the framework of corporate law or kind of dealing with private law topics? So that remains one of those areas of law that has yet to be developed. In my opinion, despite the fact, and I know that there are opinions to the contrary, both in Umakanth's white paper and Shyam's opinion, is that I think we are just one judgment away from this this gap between, are these duties under section 166 justiciable at the hands of stakeholders other than shareholders? And the Supreme Court, I think at some stage will step in, and it just takes one judgment to do that. And I think we continue to have an activist judiciary. It's not like the Bhagwati and Krishnaya days, but I think we still have a very active judiciary. And I think one of our judges, and it could be Justice Ramanna, it could be one of his colleagues, who is going to interpret that 166 is going to be justiciable, not just at the hands of a shareholder, but at the behest of a bunch of other stakeholders. Otherwise, why have it in section 166? We should have stopped there. And so they might kind of creatively interpret 245. But that's a little bit of a speculation and crystal ball gazing, which I mean, that can be the subject matter of a whole seminar by itself. Now, coming back to what's happening in the capital markets, I think Umakanth dealt with this whole issue of BRSR and sustainability reporting. Don't underestimate the importance of this. So we had what was called the BRR, or business responsibility, which was more MCA driven. But BRSR is a step change. Why is it a step change? Because firstly, it is going to be compulsory from 1st of April next year for the top 1,000 listed companies. And these are not yes-no kind of answers that have to be given. The kind of reportings and filings that will have to be made by companies they will carry legal responsibility almost like a prospectus. So if a company lies in terms of its disclosure, they are going to get sued in a capital markets action. And I think this is a massive sort of both an obligation as well as a stream of professional advice. So in fact, what we have done is we've actually created a separate practice group for this. The second thing that I think part of this whole BRSR philosophy is worth making is that apart from not just being a yes, no, tick the box kind of thing, it lays down two standards. What is a baseline standard as well as leading indicators. So a company which is wanting to comply with or will be required to comply with BRSR will not only have to sort of deal with the baseline of whether I have this policy or that policy or am I in compliance, but will have to talk about its kind of aspirations, the leading indicator that it is called, or what is best practice or what is aspirational, and therefore put in a subjective description as well, or we want to aspire to this standard. That is leading indicator. And that gets into a very tricky area because you can't under-promise or over-promise, and you have to be exactly right. So a lot of thought will have to be going into how they fill in the leading indicators aspect of the BRSR disclosures. And of course, whilst we have adopted and sort of been inspired by a lot of standards overseas, the final outcome which SEBI has come up with and the guidance notes relating to it are actually quite unique, and I think they will be setting a new global standard when it is implemented. I talk to a lot of boards, and what I'm seeing is that this conversation, it's still early days, but it is becoming mainstream. It's coming in from the fringes into mainstream, partly because of the march of regulation. But there is at least one subsection of corporate India which has started to believe that ESG and sustainability conversations are not merely compliance conversations, they're actually business strategy conversations. And the catchphrase that I've seen some of them use is that ESG or sustainability is the new digital, which essentially means that they are seeing that the future of their own corporation and their own businesses is going to be as profoundly impacted by sustainability as it has, as the last 2 decades, how digital has. Just to conclude, 2 big challenges I see on this justiciability, since we are kind of having this conversation in the context of a legal opinion and a white paper by a law professor, is justiciability and standards. So as far as justiciability is concerned, as of now, as things stand today, unless there is a Supreme Court judgment, I would agree with Umakanth's view that it's only the shareholders can really invoke Section 245 in terms of a class action. It'd be very hard for somebody else to come and knock the doors and say, I want a class action and I want damages and all of that because of some environmental degradation. So that is kind of probably the more conservative view. But as I said, we are one judgment away from a kind of a floodgates opening on this. And in the Supreme Court, in the case in April 21 of the Great Indian Bustard, where the Supreme Court has already taken one step towards, I think, interpreting Section 166 and equating the duties or to the shareholders, the environment and others, and putting them effectively on a level playing field. So I think the first chink has been opened, and it's now a matter of time before another judge actually tears it open and makes it into a full door or a window. The crack is already there, and that judgment, I think, is something which has not been talked about enough in though Shyam's opinion does refer to it, but it has not yet been talked about enough in the public domain. But the keys have already been opened. The second point, the last that I'll conclude there, which I think we're going to struggle with, but our judiciary is innovative enough, is firstly, what will be the evidentiary standards? How are you going to hold a board accountable for having failed to perform its duty? What standard are you going to apply, and what is the evidence for it? And how are you going to fix penalties? But these conversations will continue to develop. I think there will be both judge-made law as well as standards which will evolve. This is a conversation which is going on across the world. There are Singapore High Court judgments on this as well. There are judgments in the UK as well. So there's a global conversation, and India, I think, is going to be a big part of it. The last challenge, which was why this conference was held, is how do you make boards aware of this? I think at one level, it is up to our fraternity to make sure that, and we actually, as a business lawyer or a corporate lawyers community, we have unprecedented access to boards. And I think our voice is taken seriously. So frankly, I think we are the ones who will need to make them aware of the fact that the world is changing. This is not just one of those sort of compliance things on the fringes. Sustainability is mainstream. And it's for the better because, at the end of the day, when you read something in the newspapers, like what our municipal commissioner said a few weeks ago, that by 2050, Nariman Point is going to be underwater, that kind of is a wake-up call. And then there was also, and I think another report which said that of the 7 cities in the world, Mumbai is one which is going to be submerged in 100 years. I sit in Mumbai and I worry about this. So with that, I'll stop and then kind of hand it back to Anubhav for taking it forward from there.
Thank you, Cyril. You raised so many issues and I'm almost prompted to ask you further questions, but I'll hold my thoughts, right, for a bit because we have other panelists waiting. So quickly going to Mrs. Sharma. Mrs. Sharma, as a director, what is your experience on how climate change is perceived in India? Have you ever had the opportunity to discuss this issue with other company directors, and what attitudes do you encounter if you do so? Give us some broad perspective in terms of your experience on this area with respect, especially keeping in view the legal opinion and the white paper we are discussing today. Over to you, Neera.
Yeah, thank you, Anubhav. It was very insightful hearing Mr. Cyril also. So I feel there are multiple impacts of climate change on companies. On the one hand, it creates a series of new business risks. Besides most obvious physical risks like operational impact on extreme weather events or supply shortage of water, and companies are exposed to transition risks which arise from the society's response, in fact, to the climate change, I will say, such as changes in technologies, market, regulation that can increase business costs and undermine the viability of existing products and services, and in fact affect the asset values also into today's era. And another climate-related risk for companies is potential liability of emitting greenhouse gases, I feel, and an increasing number of legal cases have been, I have seen, like are rising now. There are mainly directly against the fossil fuel companies and utilities in the recent years, and holding them accountable for damaging effects of climate change. And but at the same time, I see that climate change also offers business opportunities. Firstly, companies can aim to improve their resource productivity, and thereby reducing their costs. Secondly, climate change can spur, I think, the innovation, inspiring new products and services which are less carbon incentives, or we enable carbon reduction by others. And companies can enhance resilience of their supply chains, for example, by reducing reliance on the price volatile fossil fuels by shifting towards the renewable energy. And together, these actions can foster competitiveness and unlock new market opportunities. I see the opportunity also there if they work on the climate change more effectively. And it is worth noting that the corporate executives largely agree today that their boards understand sustainability issues could be stronger. Fortunately, board members don't need to be full-fledged climate experts to fulfill their oversight responsibilities. A broad understanding of the scientific consensus will suffice most of the times, I feel, and especially when coupled with the willingness to explore its consequences for these companies. And what toll will rising seas, strong storms, longer droughts take? When these questions are particularly complex, but true experts can and should be called for into the help. We at the board level, we do discuss all these issues, but whether those issues are taken seriously, are they having a mark on the mind of the directors who are sitting in the boardrooms? And I feel a director's goal should be to understand how their management teams assesses these. and other climate related risks, what they plan to do mitigate them, how they envision sharing that story with stakeholders outside the company, like with the regulators, investors, communities, or maybe with their customers. With expectations around transparency is ramping up, boards will want to understand their management teams, strategies for aligning their framework with groups like Task Force on Climate Related Financial Disclosures, you can see. And risk oversight is the important part of the board's remit, I will say. And climate change can differ from other risks a company faces due to the potential magnitude of its consequences, I can say. But boards can still look to risk management, oversight, best practices, they can grapple with it. And I think the board should ensure that by asking their management teams the right questions at the right times, and how will the questions like how will the physical and transition risks associated with the climate change impact the company strategy, what they are actually doing on the ground to improve the environment. Has the company analyzed the opportunities that may arise from the shift to a less carbon incentive economy? What is the company's climate story? It could be a very good brand building story for any company if they are doing some story on the climate. How is it preparing for increased disclosure requirements? What additional investment is necessary to ensure that company can measure its climate impact? And what operational changes could be made to mitigate the company's climate impact? These are the few questions I think all the board members should ask the management when they are sitting in the board, and putting it in a right way in the agenda every time, and improving boardroom climate competencies and ensuring that climate change is on the table during discussion of risk management I think is the first key step. But board should not stop there, because climate change both has a corporate governance matter and is a fact of life, is here to stay. Board should ask themselves where responsibility for overseeing these crucial risks should lie, whether it lie with the full board or a committee. And what important most is the ownership of the matter is clear and it remains on the agenda. And the board should see their dynamics, whether they have the experts on the board, whether they know the subject. If they don't know the subject, should they appoint some special committee who can report to them what is happening? See, it is sometimes it is next to impossible to abreast yourselves with all the upcoming laws and what is happening around, what the other companies are doing, because we understand that the directors, independent directors who are sitting on the boards are not sitting on one company, they're sitting on multiple companies. So it is the duty of every corporate to make the knowledge bank available for the directors. And directors should also not be shying away from enhancing their learning skills. They should not that we know everything. No, we can learn all. We should be the moment they will come into this stream that, okay, let's all learn together and we can learn all with the help of the youngsters, with the help of the teams available. So I think that is the first step which the many directors can take. And if they take this initiative, lot of things can improve on the climate change prospect. And it is not the duty of only one director, I'll say. In today's era where we are staying in this world, it is a duty of each and every individual. And it is more of a not only a corporate governance duty, it is a moral duty also to provide our future generation some sustainability resources in which they can also have a better life. Like if the directors think from that angle also, lot can be improved upon. And yes, in this in India, like it is 166 is there, but still I feel there is a lot of loopholes. Like it is very difficult to say that this is the responsibility of an independent director. They are also dependent upon certain informations which are provided by the company. So proper diligence and good faith, all these things, it is very difficult to prove and make them liable or it is a long field to go, I feel like, and there are multiple laws. There is environment law, then there is a national green tribunal. We need to have a specified code where everything is available at a one click, that this is all you need to look into if you are looking for a climate change regulation. And secondly, I see that the directors on the companies where our carbon emission is there, they are more responsible, they are more thoughtful towards what changes our companies are doing, what are their plans. But the companies where there is less carbon emission, they are not into this business, and climate, like all these regulations are not affecting them. They don't have that mindset. Let's be very clear that they are not thinking on those lines. Like, okay, they are more concerned about the profitability of the business. They are not concerned about what regulations are there on the climate change. That is the fact. So the directors who are on those companies, because we know now that with the new Companies Act, there are a lot of obligations and liabilities on the independent director. So independent director who is sitting on the board of a company who is doing a carbon emission, or there is any radiations are coming out, all those are more concerned about all these steps, but not any other independent director who is sitting on the other company. So that is my view on this.
Thank you, Neera, for this candid insightfulness from the corporate side of it, and we'll catch up on this a little further. But at this point, just to broaden the discussion, I would like to invite Alex to the discussion as well, because he does extensive research in terms of how this area and the jurisprudence have developed in other countries as well. And this is given what I hear from the panelists, it is definitely an area where directors and their advisors need to start considering and think about it. Over to you, Alex. Given your extensive experience and study on this topic of climate change in other jurisdictions, how do you see the India side of things, and especially in light of the opinion and the white paper that has been released today and we are discussing today? How do you see the difference or the key differences between how this whole obligation on the boards have developed in overseas jurisdictions? Alex.
Thank you, Mr. Kapoor, and also thank you to Mr. Varottil, Mr. Shroff, Dr. Bhasin, and Ms. Sharma for what's been a really engaging discussion so far. As Mr. Kapoor says, I'm a lawyer with the Commonwealth Climate and Law Initiative, or CCLI, and I look at directors' duties and their legal obligations in light of climate change from a global perspective. So I'd like to give a few quick comments on the international context of this legal opinion, to say why it's not only commendable as an outstanding piece of legal analysis by Mr. Shyam Divan in its own right, but it also has the potential to be a significant intervention into commercial conduct and directors' duties in India in and of itself. So one of the things Mr. Shroff said was that it's a really nice opportunity to have a legal opinion come out and then be able to discuss it and what its implications might be. And one of the reasons which we do that is to disseminate the findings that we have to get the word out there into the corporate ecosystem. And that's, part of that is the role of lawyers is to be giving advice on this. We also work with regulators and other stakeholders in that ecosystem to really help to understand, help bring up that understanding of what it means to be acting in the best interests of your company, and obviously in the case of India, in the best interests of the environment, in the context of climate change. So we will share updates with this with the attendees, but if you'd like to get in touch with us about this, you can obviously follow us on LinkedIn and Twitter, or visit our website. So what's the legal opinion in the white paper in India mean? Well, they're the first of their kind of analysis under Indian law, and they really bring to the fore what directors' responsibilities are and where the potential liabilities for them lie. And what we've heard is that there are Ms. Sharma's perspective on these being real issues that directors need to think about considering and how they manage them, and also what Mr. Shroff and Mr. Varottil have said about the potential liabilities and how we might just be one step away from, or one judgment away from these being held to be justiciable. So a really interesting context in which this white paper and the legal opinion are landing. But while they're the first of their kind of this analysis under Indian law, they're actually one of a number of an increasing number of legal opinions on this topic, in which we've worked on or collaborated on, which cover jurisdictions from Australia, the United Kingdom, Japan, and Singapore. So I'd like to talk a bit about what the effects of these materials have been. It might be helpful to illustrate with an example. So our Australian convener, Sarah Barker, who is the head of climate risk governance and sustainability at the law firm Minter Ellison, instructed a leading commercial barrister, Mr. Noel Hutley SC, on a similar legal opinion. And Mr. Hutley found, similar to Mr. Divan, that directors are required to take into account climate change when fulfilling their legal obligations. So it's a very similar context to that which we have with this opinion, in that we have a really eminent barrister issuing an independent legal opinion on this topic from a commercial perspective, and finding that climate change as a financial is now a financial risk. It's clearly being considered by multiple stakeholders, and directors really need to be thinking about it in order to live up to fulfill their legal obligations. And that Australian analysis by Mr. Hutley proved to be a bit of a watershed moment in understanding how climate change is an issue, not just in and of itself for corporations, but also as a financial risk. And that was picked up by and expressly cited by the Australian Monetary Authority, which is the Australian Securities and Investment Commission, the Prudential Regulatory Body, which is the Australian Prudential Regulatory Authority, and the Reserve Bank, and then the Accounting Standards Boards, and which was in turn then picked up by the International Accounting Standards Board. So there's a similar sort of context where you have regulators who have an interest in climate change, but perhaps don't feel empowered to act on it, taking the legal opinion and using it as a springboard to bring that analysis into their own guidance and their own way of considering how these issues interact with directors' obligations. So in the Indian context, where you have the Reserve Bank, which has expressed an opinion on this, and you have the SEBI and the securities regulators who have said that this is something which they're looking into and which they expect directors to be thinking about. It's really something which brings up that standard, and which we might expect to further elevate that as this opinion is picked up and reflected. So what we saw there was, we saw something that went from a legal opinion, which is normally something which exists only in that lawyer-client context, to something which had a really wide-ranging impact on how regulators, directors, and that whole corporate ecosystem considered the issue of climate change. And we've also seen similar developments in other jurisdictions. So, for example, earlier this year, we released an opinion by Mr. Jeffrey Chan, SC, who is an eminent Singapore barrister. And again, it found very similar findings in that directors of Singaporean companies are required to think about climate change in order to fulfill their duties. And that's now been cited by the Singapore Exchange Regulation, or SGX, in part of its consultation paper on climate and diversity issues. And that was regarding a proposal that directors would need to think about, would be required to take mandatory training on sustainability issues in order to fulfill their duties. So in jurisdictions where this issue has been considered and where these opinions and these materials have come out, we've really started to see a change in how regulators and other stakeholders consider this issue, and it catalyzes a conversation and a growth in this understanding. So, we see this very much as a sort of starting point for an expanding conversation, and in turn an expanding an expansion of what it means to be acting in the best interests of your company. So I'd like to commend the opinion by Mr. Divan and his team, and congratulate him on what is to come. So thank you.
Thank you, Alex, for adding the international dimension to the discussion and sharing the opinions. The links to the opinions quoted by Alex are in the chat box, and we see a number of questions also coming in the Q&A section. I would invite any other Q&As to be given at this point of time as we are concluding our discussion. But before we do that, I have something for Mr. Shroff. Sir, you touched upon very important concepts of the new paradigm and the purpose of the corporation, right? And you did also touch on the entire new disclosures that have been done by SEBI, where not only the companies are required to publish the policy that under CSR, that is 135, but also under DSR, the sustainability regulations, and also to kind of make additional disclosures on ESG. There was also a proposal where the risk committee has been entrusted. SEBI had proposed direct responsibility on the risk committee on the sustainability and environmental issues. Hearing all that, what is your advice on standards of good governance which a director might be expected to adhere to in order to meet the standards of competence? Do these standards differ across different sectors or industries in India, or and depending on the responsibilities and knowledge of the director? And this also kind of touches upon who is more responsible, the independent or the executive team of the company, right? So I know these are early days for the entire jurisprudence to develop, but how would you advise the directors and the independent directors, as it is a duty that has been outlined in 166?
That's a great question, Anubhav, and I think the answer partly lies in your question itself, namely that these are early days. But couple of sort of general points first. Firstly, that the law does not distinguish between the duty of different types of directors. The duties, fiduciary duties, are the same. Even 166 is not specifically carved out for, it applies only to the executive management and does not apply to the independent director. So there is no such distinction in section 166. Now, that being said, I think, as we know, including there was a recent Supreme Court judgment also on the sort of liability of independent directors, there will be a practical nuance in terms of how the law is applied. And I think there will be greater obligations in terms of the executive management. But the duty on the independent directors will also, there will be a duty of diligence, which will have to be, there will be a base standard that they will have to be, that will have to be applied. They will have to be curious. They will have to ask the questions. And I think they will have to hold the executive management accountable. They can't consider themselves in an ivory tower and not ask this question at all. This was partly what was dealt with in the Supreme Court judgment that I dealt with as well, where for the first time that kind of the door was opened and 166 was brought into sort of board conversations as well. So in my view, as a practical matter, just to keep it at a practical level, I think boards will have to start apprising themselves of not only the statutory or regulatory disclosure obligations like BRSR and things like that, but they will have to start engaging in the sustainability agenda. And it's a different, there will be sector-wise differences. I think a conversation in the board of a carbon major is going to be quite different from a purely tech-based company. There will be sustainability conversations in both, but the kind of degree and the nuances of the questions will be different. I'm aware of the fact that on several boards, not just because RBI has driven this, but even boards on financial institutions, banks, and others, there are sustainability conversations that are going on, because it's not just your own carbon footprint that is relevant. The way the law has evolved and will evolve is even your vendors and suppliers, and you have to get into all of that as well. So whether you are a public or private sector bank, you can't say, okay, I'm just a bank, I'm a financial institution, and I have very little carbon footprint. But what about all the other stuff that you're doing, about the buildings that you lease, and about the fuel that you consume, and the number of flights that your executives take? I don't know whether you saw I think it was Zurich Financial or one of the global insurance companies. They've taken a decision to cut the flights that their executives take by half to reduce their kind of carbon footprint on aviation fuel that they. So even financial institutions, even those who don't have a kind of an obvious carbon footprint, are thinking about these issues. So I think it affects us all. And it's hard to say, no, this is only for the Indian Oil and Bharat Petroleum and Reliance, and all of us are all good boys and we have no carbon footprint. I'm pretty sure even as a law firm, I have a carbon footprint that I need to think about.
Thank you, Cyril. I think that definitely takes us to a position that the directors should be discussing this more actively as part of their duties. And with that, I just segue to Umakanth. Professor, do you think the directors should seek third-party advice on climate change? And if this is required to fulfill their legal obligation, what are the best practices that you are seeing in the industry? Do you see credible risk to directors being exposed to class actions and other regulatory actions in the future, especially related to climate change risk that is fast emerging? Over to you.
Yeah, thanks. Yeah, so again, the jurisprudence is not explicit, but certainly, as Ms. Sharma also mentioned, directors need not necessarily be experts in dealing with issues of climate risk, but they need to seek and obtain the right level of expertise to equip themselves to deal with this risk. So certainly the law does recognize that they can outsource to experts and obtain their advice, or even employ experts or to whom this task can be delegated. But ultimately, they will be responsible for the action. So in terms of practicality, I think there could be issues about who do you rely upon first. You have to do some due diligence. Are they the right kind of do they have the right kind of expertise that you can rely upon, whether it's consultants, scientists, or any kind of external service provider? And then how do you rely on that? What level of discussion do you have in assessing and assimilating that risk and taking this strategy forward? So I think that would be like a typical case. It would be similar to what you might find in an M&A transaction. Should you go ahead on a deal or not? Who do you rely upon? Who does the valuation? I'm just trying to draw a parallel. Maybe similar analysis may have to be done in the context of climate risk as well. The second
Can
question,
I just add one thing, Umakanth? Sorry to interrupt you. I think this is already happening, and on several private equity deals, for example, because most of the large private equity, the bulge bracket firms, are all signatories to the UN PRI, and therefore it has kind of trickled down now to the fact that when they're investing in companies, they get a ESG audit done, and they call upon people like us to actually give that. Without it, doesn't go to the investment committee as well. So this has already happened. And also, even on M&A transaction, there is an ESG kind of a report that is prepared particularly on last one basis. So this has already come into the transactional arena as well. This is now a done deal.
Yeah. Thanks.
Can I ask one thing? This is to the Cyril. I understand that these investors are doing the due diligence on the ESG from the ESG angle also. But when they are investing in the different portfolios, and how they ensure that the end investment is going to the company which is working towards the ESG.
So two things. One is that before investing, they're asking the question, and then going forward, what is BRSR meant for? BRSR is meant for having a public disclosure, so that it's like out there in the public domain that this is my kind of diagnostic or my self-diagnostic to which I'm holding myself accountable of my sustainability footprint. So that is the information which will be used by the investors, particularly the public institutional investors, before they trade on your stock. The other thing which has happened is that now it is possible to go get yourself a ESG audit done. So there are a lot of professional organizations. You can see, just like you take a blood test and you get a diagnostic of, what's your lipid profile and your this and that. You can go and get your get an ESG audit done, and you get a full report of what your footprint is.
Okay, thank you.
It's a complicated exercise, but this service exists, and there is a rating also now. There are so many rating agencies. There are ESG ratings, and the one in India is on National Stock Exchange and SES. We actually helped SES devise their intellectual model for this. But there are ESG ratings that are out there in the public domain. You can go to the NSE website and see them.
Actually, I read many reports from the different fund houses who are claiming that by 2030 or by 2040, all their assets, all their investments will be in the assets which are carbon free emission. So I don't know how they are going to achieve that. So that's why
it's good to aspire. At least if you aim for the sky, you might land up at least on the treetop.
That's true, sir.
Sorry to interrupt you, Umakanth.
Yeah, sorry. So I was just going to touch upon the second question that Mr. Kapoor asked, which I think is the elephant in the room, which is the enforcement question. You have all these duties, but what are the extent of enforcement that's possible? I would try and put it in three parts. The first is, can you use existing remedies to address climate change risk? And to me, I think that's very clear because climate change also has a financial impact. It affects the profitability of the shareholders in the long run. So it's not just a stakeholder or a soft social issue. It has a financial impact. So shareholders could potentially use existing remedies. It might hurt the company in the short term because one of the questions in the chat said, well, if a shareholder brings a claim, will it not affect the reputation of the company and bring down the value of the company? Yes, it might in the short term, but in the long term, this action may actually turn out to be profitable for the shareholders. So it's a question of long term and short term. And given the discussion we just had about ESG and so on, there's a development of what people are calling as pro-social shareholders. So Mr. Shroff mentioned about Larry Fink. So, so pro-social shareholders are not looking at myopic profitability. They're looking at other issues as well. So they can use existing framework under the law to bring action. So that's number one. The second could be 166 provides a right, but does not provide a remedy, but nothing prevents the legislature from tweaking that going forward. So if they can introduce 166, maybe there's a possibility that there could be some change in the future, but unfortunately we don't know when that's going to happen. What is the motivation for that? Can stakeholders be able to sue, etc.? But what happens in the meanwhile is the third and the most important and interesting part, which Mr. Shroff mentioned, which is a single judgment of the court can change that from the Supreme Court perspective. And I think to a large extent we may have to rely on existing shareholders or pro-social shareholders bringing various kind of actions or relying on the judiciary to intervene. I think the legislature may be a bit on the back burner unless there's a real need to do so. If there is a crisis that arises in the near future, the legislature might act. Otherwise, we'll have to look at existing mechanisms or the judiciary to intervene in the meanwhile. And we've seen examples of that happening in the Indian context already. So I think there are many avenues.
No, I don't think it's such a big leap to take. Instead of 100 shareholders, a Supreme Court judge can say that includes 100 fishermen. Yeah. And that's it. You're done.
I also think
that's your precondition for 245.
I also think it's important
what
to
I'm
know
not
that
very enthused about is the fact that it's NCLT and not a court. That's a different cup of tea.
I also think it's important to get across that it doesn't have to be. People tend to think of there are pro-social shareholders and there are pro-social investors who might be incentivized to bring such a claim for just environmental reasons, but also climate change is going to have huge impacts on the way business is done at all, which is going to lead to stock drops and business risk, and shareholders are going to be suing to account for those losses. They might not necessarily be suing to try and force a corporation to reduce their emissions. They might be suing because the way business is being done in a climate change world is just not sustainable and is leading to losses.
And the smarter ones are aware of this. For example, Reliance has jumped onto the bandwagon and is getting into hydrogen fuel. So has Adani and others. So the smarter and the bolder ones are saying, let's not treat this as a compliance issue. Let's treat it as a business strategy issue. And they've already joined that. They're going to make a lot of money.
Thank you, everyone. We are on last 3 minutes of our discussion, and we have just started to discuss this important issue. But before we close, there are a few questions from our participants that we can address one by one. I think there were 6 or 7 of them. 4 of them have been answered. The 2 open ones, then any one of the panelists can kind of take that. The first one is, what do the panelists think about corporate greenwashing? The panelists, for example, cite CEOs and corporate forums talking about the importance of ESG, disclosure and green market instruments. Royal Dutch Shell, for example, is a champion of green marketing, but is essentially a death sentence for the planet. So I think Alex is typing an answer, but if anyone wants to take that, please go ahead.
Let Alex take it, and I'll add my comments.
I'll just say briefly that greenwashing is itself a risk. If you have directors who are face liability for disclosure obligations, as you do in many jurisdictions, then greenwashing is a misleading statement and can lead to shareholder claims. And we're seeing these claims arise. There's a claim against Santos in Australia, which is underway, and there's a claim against an oat milk company in America, which started last week. Both of which are saying that they talk a good talk on climate change, but they're not walking the walk.
I think the answer is, you might find the answer in Shakespeare on, you can fool some of the people all of the time. You can fool, but you can't fool all of the people all of the time. So that's probably what, so greenwashing will eventually get caught out.
Very true, sir. That will catch up, the law will catch up to it. And I think if it is not being done with the proper intent, it could be an issue. The last one is from Niti Shikhar. Does the pluralist approach towards the interpretation of Section 166 imposes possible contradictions and challenge of the law itself, like Dr. Raghuraman Rajan in his recent publication had argued that if all shareholders are essential, then none are. It's an open-ended question, but anyone wants to make a comment on this one?
Yeah, maybe I'll just kind of make a quick point on this. I think this is a challenge that has been mounted against what they call stakeholderism, or the corporate purpose in the broader interests that have been made for quite a while. Yes, there's a risk that having too many constituents that directors need to keep in mind might ultimately benefit no one at all. And I think that's really the point that Mr. Raghuram Rajan is making. But given everything that we've discussed in the Indian context, maybe the risk management framework, develop jurisprudence surrounding this, and best practices that boards themselves are developing, and governance, this issue can be potentially dealt with. So sometimes we try to use this as a way out to critique the whole approach towards stakeholderism, but I think there are more serious ways of dealing with it, and directors have to take on that responsibility and deal with it. The world is complex. There are various competing considerations that directors anyway have to take into account, and that's part of their job. And this is one other aspect to deal with it. So I think this perhaps is not something that is going to go away, and the naysayers will raise this as a potential opposition to the consideration of stakeholders. But I think we are moving too fast in favor of considering various stakeholder interests, and directors have to just deal with it and not use it as an excuse.
And Umakanth, I think it's also important that we don't think of stakeholder interests as antagonistic. I mean, what the market and the law will do is to try and harmonize the two. It's not a binary.
Yes.
Thank you, Professor and Cyril. With that, we come to the close of the discussions. More questions are coming in, but unfortunately, we have run out of time. And But with that, thank you, speakers. I think this was an excellent discussion, and probably the first of the many we will have on such a complex space. And as we navigate through this important issue, we are highly, this discussion hopefully has deepened the understanding of director duties of India. With that, I would like to thank all the speakers and conclude the event.
Thank you.
Thank you so much.
Thank you.
Thank you,
Thank you to all
Alex.
speakers and
Thanks, Anubhav.
attendees. Thank you.
Thank you.